Those other issues being, secondly, the standard of care. Again, know this generally. It is probably most important by way of background in any question. It rarely comes up as a question on its own. So basically, you're looking at the reasonable man test here, looking at things like the probability of the harm, the gravity of the harm, the cost of prevention, the socio-utility, etc. I would say no more than background knowledge of this towards a problem question maybe involving some other tort. Thirdly then, in relation to the general negligence principles, is causation. This is an absolute, you must know this. It may come up as a question on its own, whether it be an essay question or a problem question, but it will come up in some form or other as part of some problem question on the paper. So knowledge of causation is vitally important. And simply here, just be aware of, what you need to prove to show the link between the plaintiff's negligence, the defendant's negligence and the plaintiff's injuries. Straightforward, you have your but-for test. You argue that but for the negligence of the defendant, the injuries wouldn't have occurred. There is another test that's been developed, which is conceptually difficult one to get your head around, which is the material contribution test. That lends itself to essay-style questions. And the material contribution test is basically a policy decision by courts, whereby they're more liberal in cases involving material contribution in applying causation principles. And what material contribution basically says, that if the plaintiff can prove that the defendant greatly increased the risk of the injury occurring, well then the defendant will be liable for that whole injury. So this has been criticised by Owen Quill in his textbook as equating risk with cause. That under general causation principles, or in general tort principles, you must prove in the balance of probabilities that the defendant caused your harm. In other words, 50% plus, okay, prove in evidential terms. Material contribution, all it requires of the plaintiff is to show that there was a great risk, or that the risk was increased by the negligence of the defendant. If you can prove that, then the courts in specific instances will hold full liability against the defendant. Your key cases there will be the McGee case versus the National Coal Board. You have your Wiltshire case. You also have Fairchild, a recent decision. Don't confuse material contribution with concurrent wrongdoers. Concurrent wrongdoers involves a situation where there's two or more defendants who have caused the injuries. You just don't know to what extent. Okay? Material contribution, on the other hand, applies to a situation where you can't prove that anybody caused your injuries. So in a situation where you can't prove anyone caused the injuries, what you then try to prove is that, well, one of the defendants greatly increased my chances of getting the injuries. Okay? So they're very similar, they can seem very similar, but make that distinction between the two. In relation to causation as well, certain proofs are very important here. The doctrine of res ipsa loquitur and the doctrine of novus actus interveniens. The question came up a couple of years ago, discussed the proofs of negligence, and it confused a lot of students. All that question was asking wasn't asking you, what do you have to show to prove negligence? It was a question on evidence in tort law. It was asking you, what are the evidentiary rules in relation to proving negligence? So it had nothing really to do with proving the essential elements of negligence, but rather, what are the evidential rules that may assist you in proving that? So answering that question, the proofs of negligence, one, what is the standard of proof? It's the balance of probabilities. Criminal law, beyond all reasonable doubt. Civil law, on the balance of probabilities. That's the first issue. Secondly, the doctrine of res ipsa loquitur. The thing speaks for itself. This is very important in causation terms. And remember, this is an exceptional doctrine, even more so exceptional following the Hanrahan versus Merck Sharp Dome case. And basically, this is where the plaintiff alleges that the facts, the circumstantial evidence is so strong that it raises an inference of negligence. So in other words, I don't know, you go into a doctor to, I have no idea, you go into a doctor to just have a checkup, and you're suddenly killed by the doctor through some medical misadventure, okay? Your family are bringing a claim there, okay? All they have to do in that situation is say, well, res ipsa loquitur, Your Honour, the thing speaks for itself. He went in to have a fairly normal procedure done, he was dead. So it raises an inference. Now, of course, the defendant can dispel that inference, but be familiar with the doctrine of res ipsa loquitur. I think it will be important for the upcoming paper. And also the doctrine of novus actus interveniens. Both of these, again, are the subset of causation. And novus actus interveniens, basically it says that where some outside intervening act comes to break the chain of causation between the defendant's original act and the plaintiff's injuries, well, if that act is an unforeseeable, negligent act, that act will be taken to be the new cause of the injuries. So if you're driving down the road, you're driving negligently, you injure somebody, you hit the pedestrian, you break his leg, you call the ambulance, okay? The two guys on duty in the ambulance that night have been drinking heavily. They arrive at the scene, but they drive over the pedestrian's head because they're drunk. And now in this situation, as a result of you hitting this person, they're now brain damaged as well as a broken leg. Now obviously, you set that domino effect in motion. If you never hit the pedestrian, the ambulance never would have been called, etc., etc. But in law, there will be a break in the chain of causation between the ultimate damage, the brain injury, and your negligence, striking the pedestrian. There was an intervening act which is outside your foreseeability, and that was the drunk driving of the ambulance driver. So novus actus intervenes, very important in relation to causation. One final point on the general negligence principles then is the issue of remoteness. Don't forget that. Time and time again, it'll come up in a question. You might have a problem question and it'll say, discuss the extent of liability, or discuss the extent of Mary's liability. That's a question on remoteness of damage. It's telling you how far is Mary liable. The rule on remoteness basically says in negligence, you're responsible for all the foreseeable consequences of your negligence. If you're talking trespass, don't forget this, it's the direct consequences rule, re polemis. Okay, so that's negligence in general. You may get a specific question on causation. Causation to me would be the most important topic within that, followed closely by the duty of care. Either way, background knowledge of that I think is vitally or essentially important to the paper. Moving on then, psychiatric damage is always a popular question on all tort examination papers. And just because it came up in the March 2007 paper, I would not rule it out because of this. I would definitely focus on it being an essay question this time around, however. So it might be discuss the Irish and English approaches towards psychiatric damage. Just know your general issues in relation to psychiatric damage, that it's treated differently by the courts because of its nature. It's intangible, it can be easily faked and exaggerated, no ends to claims and so on and so forth. Also note as well that it's part of the duty of care. Do you owe a duty of care in relation to causing psychiatric injury? Key issues in relation to this, distinguish the English and Irish approaches. In England, they have very much gone down the route of the primary and secondary victims. In other words, the primary victim is somebody involved in the incident itself, where they witness a horrific accident and think they could be hurt or they could have been injured as well. They're a primary victim, ordinary negligence principles apply to them. The secondary victim, on the other hand, is the victim in the Hillsborough disaster case, who comes upon the scene or comes upon the immediate aftermath of the scene. And in England, they've introduced these very strict rules in relation to limiting those claimants. And those claimants will not succeed, notwithstanding that they've suffered a psychiatric illness, notwithstanding that it may have been deemed to be reasonably foreseeable, but for policy reasons, going back to our policy, the courts decide they're not owed a duty of care because 1, they don't have a close tie of love and affection, 2, they didn't directly perceive the incident with their own eyes, 3, they didn't come to the scene or the immediate aftermath in time. So a very strict approach in the United Kingdom, which has led to the White decision, whereby rescuers and the police force working that day were not entitled to claim because they were considered to be outside the zone and therefore had no relation with the victims of the disaster itself. Ireland, it's Kelly versus Hennessy. Common mistake by students time and time again in tort papers is discussing Alcock as the be-all and end-all. That's the law. It isn't. That is the United Kingdom. That is English law. Remember what jurisdiction you're in. You're sitting in Irish paper, so Kelly versus Hennessy is your key case. Learn off the 6 points in Kelly versus Hennessy that determine when you can succeed in a psychiatric damage claim. And basically, it's much more flexible. You don't necessarily have to prove it was your parent or your child or your husband and wife that was involved in the incident. Cuddy versus Mays is a recent High Court decision in 2003 that recognised the claim of a brother to succeed where he was working as a hospital porter. But again, make that distinction clear. Moving on to economic loss. And I think there's a very strong chance economic loss will arise in the paper. Economic loss is basically the Irish courts have adopted a categorical approach whereby they divided certain cases into different categories, trying to determine whether you should recover for such loss. Probably the most important, by far and away the most important, is negligent misstatement. And this can come up probably in relation to a professional negligence question as well. Solicitor gives negligent advice, or accountant or auditor gives negligent advice, thereby causes financial loss. So in this area, note from the beginning that financial loss is treated slightly differently to physical loss, very much like psychiatric damage, because of the domino effect. It could go on forever and ever. Note that there are specific categories recognised under Irish law. Negligent misstatement and Headley Byrne versus Heller is your key area there. That in certain circumstances where a person who holds himself out to have specific expertise and knowledge, gives advice knowing that advice will be relied on, and the plaintiff relies on that advice to his detriment, causing him damage. That's basically your negligent misstatement. That is why I said at the very outset of this presentation that I have no crystal ball here. I accept no liability whatsoever for my advice here, because I wouldn't want you to rely on this advice and fail the examination and try and ground a claim against me.